during the trial stage of court proceeding, and especially civil court proceeding, then the the party that's about to examine its witness, especially when that witness has a written statement, which of course they do not have a written statement, they have a testimony in criminal trials, and this is why I made the distinction, will ask the judge and trying to get to the better side of the judge, which will in turn try and pressurize the other parties into accepting the written statement as a form of evidence without being read. Now, this seemingly innocuous suggestion, which is just suggestion, just because it's a suggestion, you have rights to decline if you want to, and I want you to know that. I don't want you to cave in the face of this urban manipulation of trying to show that that you work in liaisons with the court, and you do not want to be perceived as being an attorney, to not to cave in and not to and to wonder and think about the consequences that this might bring to your client, right? I just want you to wonder that, because it has consequences. Just because he asks for that piece of evidence not to be read, right? You have to know that if it's not to be read, that means you accept its contents. When something is not read, that means it is going to be treated as it's already been read. And when it's already been read during the examination in chief, and that means that evidence has been adduced before you even had the chance to raise an objection with regard to that evidence. And remember, like in my previous video when I talked about raising objections at an early stage, you raise the objections, especially raise the objections when you at the examination in chief stage, before answers are going to be offered, right? When certain questions are being asked, which you do not want to have certain answers being given because you think they're not permissible, you're not going to be able to raise an objection with regards to permissibility, either on grounds of the evidence, either grounds of relevancy, either on grounds of inconsistency with the pleadings, what's being raised in the pleadings. You're not going to be able. If you want to raise objection, you're not going to have to take this suggestion, which is basically a threat to your case in disguise, dished out to you, but yet you have this one clue that it's been read. You already accept it's being read, and that should basically raise the alarm that it's going to become an exhibit, or else why would someone want to accept it as evidence? Why would someone ask for it to be accepted as evidence without any deeper implications? Why would the party that conducts the chief examination gain by just saving some court time? He's absolutely nothing to gain. He's not there to save the court time, just by advancing his evidence. Because if he wanted to save the court's time, he wouldn't have forwarded his case at all, right? So you have to think of all those things. Just don't play nice and at the expense of your clients. Now, a lot of you are going to argue that it's well established in case law and precedent, especially in common law, that when evidence is not permissible, regardless of the fact that an objection has been raised or not raised with in relation to it, the judge must not take it into account when he assesses that evidence. Yes, of course, I agree with that. That's really nice. That makes a nice story. But in practice, do not forget that when you have not raised during examination chief, your objections before the evidence is used, that means before the witness either answers to certain questions that will provoke answers in form of evidence in form of answers, that you think should not be, are irrelevant or impermissible. If that's the case, then the judge will hear that evidence, and if he hears that evidence, it might affect him one way or the other. He might still, at the end of the day, follow the law, but he will be affected, and you don't know what's going to be at the back of his head, having heard that evidence. So the whole rationale here is like twofold, right? One is, yes, for you to place an objection there in time and not make it permissible. So the judge basically makes a ruling, and the sooner he makes a ruling, right, the better the chance of you having the evidence thrown out of the window are. If you move on, like because let's say if you wait on him to unilaterally consider the evidence, not permissible. One, he may not, but second, if he does, he might consider it permissible. He might consider it permissible at the end of the day easier than he would have had at the beginning of the trial. And another thing I would like to give you food for thought on is that you will prevent the judge from hearing that evidence in the first place, because if he does not hear the evidence, yet he may rule that it's not permissible at the end of the day, but he might have been affected. You'll never know that. He might have been affected. It might bolster his thinking in favor of the other party in other ways, and he will just find a way, thanks to scientific evidence. There's many ways. The brain always wants to follow a certain pattern once it has being biased, and the judge may be biased, easily to bias. Judges are human beings at the end of the day, and through all this legal jargon and legal technicalities behind this facade, they can be legally biased, right? It's like they get biased by seeing a certain pattern from an objective, subjective point of view, or objective point of view, whatever you want to call it, but they still get biased by this pattern. So one less pattern, it's a lot better for you. And finally, like at length, you will stand better chances of that evidence being ruled impermissible, not being taken into account, and thus not having to take things to a higher level, like to the Court of Appeal, where you will require more money, more time and effort, and probably your client will not be in the mood to pursue things further. So you have to think of all those. You have to think of all those considerations through the totality of the circumstances. So keep an eye out for this suggestions that may happen before the trial begins. I will post more videos. The previous video that I posted with regards to examination chief and raising your objection in time is sort of relevant to that, which is the previous video that I posted. You might as well want to have a look at it as well. If you like my videos, just subscribe to my channel.